issues were at that time?
Sure. So we think back to the history of the death penalty, we have to go back to the Dark Ages, the Middle Ages, and we see executions used routinely. And actually during the founding era, the death penalty was a mandatory punishment. If you were convicted of certain crimes, not just including murder, but other crimes as well, many different felonies, you would be executed, put to death. And it was a mandatory punishment. So we look back at the history of England, from which we derive a lot of our at least the legal jargon of the Constitution. And we see in England they had what was called the Bloody Code. The Bloody Code was actually a series of laws that made over 200 offenses punishable by death. Everything from disturbing a fish pond to murder. And part of the reason that these codes existed is because they didn't really have any place to put people for long periods of time. They didn't really think of the idea of the penitentiary until later. So, and the idea of sort of the divine right of kings, that the kings would sometimes pardon people, use mercy as sort of a way to not put people to death, but a lot of crimes were punishable by death, and it was a mandatory punishment. And so at the time of the founding fathers, we had the same idea. The first federal crime bill was in 1790, the Crimes Act, and it made several offenses punishable by death, although at that time a lot of the action was actually taking place at the state level for the punishment of crime. So let me talk a little bit about the state constitutions in a minute. So the first person to really advocate against the death penalty in a very comprehensive way was somebody who's known as the Marquis Beccaria. He was an Italian aristocrat from Milan, was just 26 years of age when he published a book called Die Delite e del Pene, which was the Italian version of a book that was translated into English as On Crimes and Punishments in 1767. And note that was just a little bit after the Stamp Act riots were happening. And so his book came at a very opportune time for the United States because he wrote against tyranny. He also wrote against the death penalty, and he wrote against torture. So at that time, I talked already about the mandatory death penalty. When we move into the Enlightenment, Montesquieu, the French jurist, was writing about the concept of proportionality. And Beccaria comes right after Montesquieu, viewed Montesquieu as sort of the immortal Montesquieu. And Beccaria writes about proportionality between crimes and punishments and says that we should favor certain punishments over the severity of punishments. And he, again, was the first writer to really write comprehensively against the death penalty. Dr. Benjamin Rush, who was right here from Philadelphia, was considered the American Beccaria and advocated against the death penalty. Actually, right before the Constitutional Convention in Philadelphia, he called for the abolition of the death penalty for all crimes in March of 1787. So he was the person that was probably the biggest disciple of Beccaria. There was another man, William Bradford, also from Pennsylvania, who was the Pennsylvania Attorney General and also became the Attorney General of the United States under George Washington, who was also a big disciple of Beccaria and wrote a pamphlet in 1793 asking the question of whether the death penalty was necessary even for the crime of murder. And at that time, he concluded that the death penalty was not necessary for all sorts of different offenses. As to murder, he said, well, the evidence is still not in yet. We need a period of experimentation to decide if the death penalty is really necessary. And that was really a key question during the Enlightenment. Both Beccaria and Montesquieu asked the question, is the punishment absolutely necessary? And when we think about the influence of this book, Beccaria's book, we see that George Washington, Thomas Jefferson both bought copies of the book in 1769. Jefferson actually, in his autobiography, which he writes later in the 1820s, said that Beccaria had convinced the reasonable world of the unrightfulness and the inefficacy of the punishment of death. And so Madison also was reading this book, referred to Beccaria as a philosophical legislator, because again, at that time, these were new ideas. And the penitentiary system had not yet been developed. Actually, in Philadelphia here, which is very interesting, the penitentiary system was being developed at the same time that the Constitution and the Bill of Rights were being debated. So the Walnut Street Prison opened up in 1790, just a year before the ratification of the Eighth Amendment in 1791. So all sorts of founding fathers admired this book. A lot of them didn't believe that the death penalty was inappropriate for murder. There were still a lot of people who believed that Beckery maybe went too far at that time because the penitentiary system had not really been fully developed. We didn't really see a building out of the penitentiary system fully across all the states until sort of the era of Jackson. We see penitentiaries being built on a state-by-state basis. But just to give you a little bit of a sense of the history of the Eighth Amendment, the language cruel and unusual punishments actually comes from the English Bill of Rights of 1689, which was adopted after the so-called Glorious Revolution of 1688 in England. And so that's where we get the words, and then George Mason included that language in the Virginia Declaration of Rights, the prohibition against cruel and unusual punishments. Interestingly, in the Northwest Ordinance, the prohibition is cruel or unusual punishments. A man named Nathan Dane was involved in drafting the Northwest Ordinance. So we have, and at the state level, you see some state constitutions talk about cruel or unusual punishments, and some talk about just cruel punishments, and some talk about cruel and unusual punishments. Madison was from Virginia, was involved in pushing through the Bill of Rights, and he used the language from Virginia, cruel and unusual punishment. So that's the language we end up with in the Constitution in 1791.
Okay, thank you, John. So, Carol, I'm going to turn to you before we turn to your brother, but you're going to, if you don't mind, talk to us a little bit about sort of the period after the founding and how and you're going to lead us up to sort of the modern era.
Yeah, well, it's important to realize that for most of American history, the U.S. Supreme Court had nothing to say, really, about the American death penalty. Today, that seems foreign to us. We know that if you have a question about the death penalty, almost certainly it's going to end up in Washington in front of the U.S. Supreme Court. But for most of American history, the Eighth Amendment, and indeed the entire Bill of Rights, applied only to the federal government and not to the states. So in recent years, from 1976 to the present, we've had over 1,400 executions in this country, but only 3 of them were under federal authority. So states are really where the death penalty action happens, and for most of American history, they were in charge of the death penalty, and the Constitution was really not in the picture. And because states were in charge of the death penalty, we began to see very early on really strong regional disparities in the use of the death penalty that we see today. We know, for example, that states like Texas, I'm not blaming my brother, he's just from Texas, Texas, Alabama, Louisiana, Florida, Georgia, the Deep South is where most executions happen today. And this started very early. In the pre-Civil War South, the death penalty was thought indispensable to control a large enslaved population. You couldn't really put them in jail. They were already in slavery. So slave owners thought that the death penalty was a very important tool of essentially terror to keep slaves who might think about escaping or using violence or against their masters or fomenting slave insurrections. The death penalty was very important as a backstop there. So southern states were absolutely not at all interested in limiting or getting rid of the death penalty. And they had, frankly, disparate codes. One set of codes for one set of capital statutes that applied to slaves and indeed to any black person, even freed, and a different set of punishments, a much smaller and narrower set that applied to white people. At the same time, in the North and the Midwest, we saw the beginnings of abolitionism and narrowing of the death penalty. In fact, Pennsylvania was one of the first states to narrow the death penalty. As John just said, in Pennsylvania, it was thought for the first time, before even the 19th century, that the death penalty was not necessary for all murders. So the Pennsylvania legislature in 1794 came up with a brand new thing called degrees of murder. So we've all heard about first-degree murder. That was invented here in Pennsylvania, and it was invented to designate those murders for which the death penalty was necessary. And other murders, other degrees of murder, were still murder, but not ones for which you could get the death penalty. And then Pennsylvania was not one of the first states to abolish the death penalty, but some of the states in the Midwest Michigan, followed by Wisconsin and also Rhode Island. In the 1840s and 1850s, these states were the first jurisdictions in the English-speaking world to abolish the death penalty, and they remain abolitionists to this day. So people who see the United States as an outlier with regard to the death penalty, we're an outlier in both senses. We were one of the first places in which abolitionism took root in the mid-19th century, but also we remain today one of the, really the only Western democracy that still has the death penalty. Even after the Civil War, however, we did not see these regional disparities dissipate. In fact, in the South, there was great fear of the freed black population, the fear that they might engage in violence against their former masters, and particular paranoia that freed black men might rape white women. And there was what one historian calls an orgy of racially based violence in the South, a period of lynching. And these extrajudicial executions were such a strong force that in the period at which they hit their peak, the last decade of the 19th century, the 1890s, there were considerably more lynchings in the United States than there were legal executions. And it was, in fact, these regional disparities and lynching in the South that led the Supreme Court first to begin to step into capital punishment in the United States. So you have to understand that many of these southern states, the governments of these states, did not like the lynch mobs. These were an affront to sort of state control, and many of the most progressive legislators in the South very much fought to retain the death penalty against abolition on the grounds that it was necessary to prevent lynching. That if the state were to prevent lynch mobs from doing their violent extrajudicial executions, the state had to be willing to quickly execute, especially black defendants who committed crimes of violence against white victims. So we ended up having what legal historians have called an era of legal lynchings, where basically sheriffs and law enforcement agents in the South would hold off the lynch mob, which would be outside the courthouse, and they would say, don't worry, we're going to have a trial, and this defendant accused of killing or a white victim or raping a white woman will be executed by sundown. And that's exactly what happened. You'd have these incredibly quick trials followed by sentencing and execution all in the very same day, in order to forestall the lynch mob. And it was these legal lynchings that led the Supreme Court first to begin to think about intervening in a constitutional way in the death penalty in the United States. So I just want to quickly tell you about two cases in the early 20th century of this type, where the Supreme Court began to intervene. So one of these cases, I doubt that anyone in this room has ever heard of. The other, I think many of you may be familiar with. So the one that no one's ever heard of, in 1906, a man named Ed Johnson, a black man, was accused of raping a white woman in Chattanooga, Tennessee. This gave rise to a great hue and cry, and we had one of these legal lynchings. The law enforcement agents arrested him. There was a very quick trial, very scant evidence. The victim testified at the trial. I will not swear he is the man, but nonetheless, he was convicted and sentenced to death in the same day. But the Supreme Court got wind of what had happened, and Justice John Marshall Harlan, who was the justice who had actually dissented in the famous case of Plessy versus Ferguson, the one that said that separate but equal was okay. John Marshall Harlan dissented, saying separate but equal is not so okay. That case had happened 10 years previously. John Marshall Harlan said, I want the Supreme Court to hear about Ed Johnson's conviction and sentence. Well, that did not go over well with the lynch mob, which, with the help of local officials, kidnapped Ed Johnson from his jail cell, took him to a bridge over the Tennessee River, and hanged him and shot him more than 50 times, including 5 times at point-blank range by a deputy sheriff. And the deputy sheriff left a note pinned to Ed Johnson's body, and the note said, Justice Harlan, come get your N-word now. So that was the Supreme Court's first experience of trying to engage the Southern practice of legal lynching. 20 some odd years later, in a case many of you probably will have heard of, it was 9 young black men who were accused of raping 2 white women on a rail car. They came to be known as the Scottsboro Boys because they were arrested in Scottsboro. And they were boys not in the derogatory sense of black men. They were boys. All of them were teenagers. Not one of them was older than 20 years old. And they were tried very quickly and sentenced to death with essentially no legal representation. This time, for the very first time, the court asserted jurisdiction over the case, heard the case, and announced the first special constitutional legal rule. They said that in death penalty cases, defendants cannot be tried and sentenced to death without a lawyer. Now, this rule would not be extended to all defendants in serious criminal cases until the 1960s, until Gideon versus Wainwright, Gideon's trumpet. We all remember Henry Fonda playing Clarence Earl Gideon in that movie. That decision was preceded 30 years previously by Powell versus Alabama, the Scottsboro Boys, in the US Supreme Court. So that was really the Supreme Court's shot across the bow to the American death penalty from the Constitution.
Thank you very much. And I should hasten to add that in my rush to get us situated, we are, of course, talking today about the death penalty and drawing to some extent from the wonderful books our panelists have written. I want to just remind you of their titles, but we're going to come back to them a little bit later. Carol and Jordan have written together the book called Courting Death, the Supreme Court and Capital Punishment, which is a terrific overview and in-depth, really, history of capital punishment in the country. And John has a book, Stephen Breyer Against the Death Penalty, which includes not just his terrific opening essay, which provides as well an overview on capital punishment, but Justice Breyer's views on capital punishment, about which we may hear a little bit later. But Jordan, you're going to tell us a little bit now about the modern era, how constitutional law, or particularly Eighth Amendment jurisprudence, looks today.
So the modern era of the American death penalty really begins in 1963 in a case that was an eerie echo of the Scottsboro Boys case. In 1963, an African-American man had been convicted for raping a white victim, and he sought review in the US Supreme Court, and the Supreme Court actually issued a non-decision. It decided not to hear his case, but in the course of not hearing his case, Justice Goldberg wrote what's called a dissent from denial of certiorari, an explanation of why he thought the court should have heard the case. And he said for the very first time that any Supreme Court justice had said that the death penalty might be unconstitutional. And he said it might be unconstitutional when applied for the offense of rape. And that decision, issued in the same year as Gideon's trumpet, as Gideon versus Wainwright, led to the effort to attack the death penalty constitutionally. So his dissent from denial explained some of the reasons why he thought the issue was worthy of the court's attention. Interestingly, one of the things that he made prominent in that dissent was the issue of race discrimination. But at the behest of Chief Justice Warren, he eliminated any reference to rape in that dissent. Nonetheless, the dissent caught the attention of the premier civil rights organization in the country, the NAACP's Legal Defense Fund. And the Legal Defense Fund, which had always regarded the death penalty as an issue of racial justice, decided to make the death penalty one of its central issues. And what they did was they decided upon what they called a moratorium strategy. They thought that if they could bring executions in the United States to an end, that might bring the issue to the Supreme Court, and that the Supreme Court would ultimately declare the death penalty unconstitutional. So they came up with all sorts of bases for challenging the administration of the death penalty. And this all happened at a particularly good time for a number of reasons. The support for the American death penalty in the 1960s was the lowest that has ever been recorded in terms of public opinion. the only Gallup poll in American history in which more Americans voiced opposition to the death penalty than support for the death penalty was in 1966. It was also in the middle of the civil rights movement and the anti-war movement. And so what was remarkable is that the Legal Defense Fund strategy of trying to bring executions to a halt actually was successful. In 1967, executions ground to a halt. Legal challenges were being filed in all of the jurisdictions, and cases were being filed in the United States Supreme Court. And ultimately, the issue of the death penalty's constitutionality reaches the US Supreme Court in 1972. And surprisingly, the Supreme Court held in 1972 that all prevailing capital statutes were unconstitutional. And it was a strange sort of landmark opinion, because at the time that it was written, it was the longest opinion in Supreme Court history, several hundred pages. It was a 5-4 decision in which none of the 5 justices who supported the result agreed with each other. They all wrote their own opinions explaining why they thought the prevailing death penalty practice was unconstitutional. The 4 dissenters all wrote their own opinions. But the perception at the time was that this was the end of the American death penalty. The headline in the New York Times the next day was as big and as bold as the headline that had declared that man had walked on the moon when that headline had issued 3 years earlier. But what was not expected was that there would be an intense backlash to that decision. 35 states in the next 4 years passed new capital statutes trying to comply with the Supreme Court's decision. The Supreme Court's decision in 1972, only 2 justices, Justices Brennan and Marshall, had declared that the death penalty as a punishment was unconstitutional. And the other 3 justices had focused more on its administration and the failure of states to give any sense of guidance as to who should live and who should die within their capital schemes. So 4 years later, with the intense backlash, which again, it was bad. This was bad timing, just as it was good timing in the early to mid 1960s to take on the death penalty issue. By the mid 1970s, violent crime rates in the United States had climbed enormously, and so that I think in part fueled the backlash, along with some political developments. President Nixon had initiated his sort of Southern strategy and politicizing criminal justice issues as a way of pulling Southern Democrats away from the party. So there was a lot of resistance to the Supreme Court's issuing a decision to end the death penalty. And so 4 years later, in 1976, the Supreme Court revisited the constitutionality of the death penalty with 5 of the new 35 statutes that had been passed in the interim. And in 1976, the court upheld 3 of those new statutes, declared that the death penalty as a punishment was a constitutional punishment, that it could be justified as serving deterrence or retributive grounds. And the next 40 years, which really brings us to the present day, the United States has lived as an exceptional country. We're viewed as exceptional in part because we're the only Western democracy that retains the death penalty. But what Carol and my book focus on is the fact that we're also exceptional in that we're really the only jurisdiction in the history of the world that has sought to tame the death penalty through extensive constitutional regulation. And we really have had 2 periods that have been sort of significant in constitutional regulation. The first 20 years of constitutional regulation, we think and we argue, strengthened the American death penalty. Even though the constitutional rulings actually did very little to improve or solve some of the problems that the court had identified in terms of the arbitrary and discriminatory use of the death penalty, the very fact that the court was embracing constitutional regulation, I think, gave the appearance of improvement, what we call legitimation. that the American people and the actors within the criminal justice system became much more comfortable with the American death penalty because the court had undertaken regulation, even though that regulation was quite minimal. And so death sentences and executions rise in the 1970s and 1980s and through the mid-1990s. And people felt very comfortable with the American death penalty. Polling support for the death penalty reaches its highs in the early 1990s. And in some ways, it looked as though the Supreme Court had saved the American death penalty. The American death penalty was withering in the 1950s and 60s. There were very few death sentences, few people on death row. And yet the backlash to the Supreme Court decision, I think, gave a boost to the American death penalty in a way that actually may have even revived it. But one thing that seems to have been unanticipated and unexpected is the way in which constitutional regulation would eventually undermine the American death penalty. That even though the constitutional rulings themselves were quite minimal and unintrusive, whole institutional structures were built around the new constitutional regulation of the death penalty. A whole cadre of lawyers emerged that hadn't existed in American history. Lawyers who would be specialists for capital trials, who would work in state post-conviction, who would work in federal habeas proceedings. All of a sudden, capital defendants had rights to several layers of appeals that didn't exist prior to the court's intervention. And as a result, the death penalty has become enormously expensive to administer. Litigation has been incredibly intrusive, even though the underlying constitutional norms remain quite limited. So we now have a world in which constitutional regulation of the death penalty has made the death penalty unsustainable. Everyone is familiar with the lengthy delays that now occur between capital trials and executions. In many jurisdictions, there are no executions at all. In some jurisdictions, it takes 20 or 30 years for executions. The largest death row in the country, California, with over 700 inmates, execution is only the third leading cause of death behind suicide and natural causes. The cost of the death penalty has become enormous because of the constitutional regulation. They actually have come up with a way of calculating the cost of the death penalty in California by looking at the number of executions and dividing all of the costs associated with capital punishment. And the staggering figure that we've arrived at is that it costs approximately $250 million per execution in California. So that's really led to the possibility that the death penalty might ultimately be invalidated constitutionally. And I think John's book really offers an interesting portrait of how that constitutional abolition might occur.
Thank you, Jordan. So you have the special opportunity to have 4 law professors sitting up here, and you just had a wonderful overview of a lot of law and jurisprudence, but you may not have even realized it, which is the best of all worlds. Having said that, I'm going to ask John to sort of then bring us back to his book, really. And the focus there is obviously on Justice Breyer's viewpoints regarding the constitutionality of the death penalty. And obviously Justice Breyer is one of the important voices right now on the Supreme Court. He's spoken in dissents, which means he didn't prevail in the cases, but his dissents, I think, are worth listening to, and that's what you're writing about, or what you're excerpting in your book.
Yeah, and I think it's important to put a little context in this as well, and globally right now, Europe is basically a death penalty-free zone at this point. They have a European Convention on Human Rights, and they've adopted protocols. That protocol number 6 abolished the death penalty during peacetime. Protocol 13 abolished the death penalty including during wartime. So in Europe, there's no death penalty eligibility. Actually, when the Rome Statute was passed for the International Criminal Court, they decided for crimes against humanity, genocide, war crimes, that a life sentence would be the maximum penalty. So under international law, there's actually been a a movement to actually have a moratorium imposed at the United Nations. South Africa's constitutional court actually declared the death penalty unconstitutional back in the mid-90s. So that just gives you a little sense of where we are right now. As Jordan mentioned, Justice Marshall and Justice Brennan were the two justices who declared that the death penalty was unconstitutional as a cruel and unusual punishment in all circumstances, and they sort of relentlessly dissented. For a period of time in the Supreme Court, we really haven't had those same kind of voices until now. In the book, it reprints Justice Breyer's dissent in the Glossop versus Gross case, which is a case from 2015. We've had two major challenges to lethal injection that come before the Supreme Court: the Bays versus Reese case out of Kentucky in 2008, and the Glossop versus Gross case in 2015 out of Oklahoma. And in that case, Justice Breyer writes the dissent, and he's joined by Justice Ginsburg. And they said in that dissent that it's likely that the death penalty is a cruel and unusual punishment. And for the reasons that I'll talk about, I don't think it's likely that they would go back and now change their view on that, because they give a very detailed analysis of why they think that the death penalty is unconstitutional. But they've simply called for a full briefing on the issue so that more detailed factual information can be made available. So in the dissent in the Glossop case, Justice Breyer really lays out three reasons why the death penalty is unconstitutional. One is that the convictions are unreliable that we're seeing coming out of the criminal justice system. There's been, in the modern era, sort of the mid-1970s on, we've seen over 150 cases where people have been exonerated from death row. Now, some of these people might quibble about individual cases, but there's certainly been over 100 cases where people that were innocent ended up on death row and then were later released. Justice Breyer talks about a few of those cases in the book. One of them you may have seen in the news is a guy from Louisiana named Glenn Ford, who spent literally 30 years on death row in Louisiana, was exonerated, and then sadly a year later died of lung cancer. There was another case that Justice Scalia actually had once made a reference to this guy's case and sort of portrayed him as the poster child for the death penalty. Turns out years later, DNA exonerated him. He was not guilty of the crime. And we have knowledge of false confessions that have been made by various people under various circumstances, including you think about the Central Park 5 case. It's just an example of that. The second reason Justice Breyer gives is the arbitrariness of the death penalty. This goes back to something Carol talked about. We have sort of a regional aspect of the death penalty. We have what's called the death belt. You look in the states of the old Confederacy, you see that the death penalty is still being used. But even in places like Texas, we're actually seeing a decline in the use of death sentences. But we still see the death penalty really isolated to actually not even states anymore. It's sort of individual county by county. So you have to not just look at the states, but you have to look at individual local prosecutors to decide whether or not the death penalty is being used in that particular place. And so one of the things Justice Breyer talks about is a very small percentage of counties that are actually actively using the death penalty any longer in the United States. The third thing that Justice Breyer talks about is what's called in international law the death row phenomenon. And this is the idea that somebody spends an enormous amount of time on death row under the conditions of death row, and that has a cruelty all of its own. There was actually a case out of the European Court of Human Rights, the Soring versus United Kingdom case, that dealt with a refusal to extradite somebody to Virginia in that particular case, where they would face this death row phenomenon. And other foreign jurists have recognized this concept. The U.S. Supreme Court has not yet recognized it. Justice Stevens wanted to take up this issue, issued a dissent in a case called Lackey versus Texas in, I think it was 1995. And Justice Breyer and now Justice Ginsburg have called for the Supreme Court to take up this issue of sort of the psychological aspect of the death penalty. Just the other day, Justice Breyer issued a new dissent in which the person had been on death row for 40 years. And obviously, if you look back at the founding era, this is not something you would have seen back in the founding era. The executions were carried out very expeditiously after the imposition of the punishment. In fact, one of the principles of Beccaria, who I talked about, was that there had to be a close association between the crime and the punishment. So we've gone about as far away from that as you can. Justice Breyer, in his dissent, points out that we have an average of 18 years in the United States between the imposition of the death sentence and the actual execution. And for those reasons, Justice Breyer says the death penalty has become unusual. I will say that, back in the founding era, there was a lot of people, including Dr. Benjamin Rush, who referred to the death penalty as cruel. But you could not have said at that point in time that it was unusual, because it was the mandatory sentence. If the person was convicted, they would be sentenced to death. Once you move to discretionary sentencing, though, and you see the numbers of executions and death sentences declining, it becomes highly unusual, highly arbitrary. And I know Kara may talk in a second about a case that was just a federal judge looking at the federal death penalty, sort of looks at some of the things that Justice Breyer looked at and concluded the death penalty was arbitrary, but the judge felt his hands were tied because the Supreme Court has still declared that the death penalty is constitutional. But maybe the last point I would say is that if you look at corporal punishments for a second, non-lethal punishments, actually there was a case called Jackson versus Bishop that was decided in the Eighth Circuit, and actually Justice Blackmun, who was then on the Eighth Circuit, he wasn't yet on the Supreme Court, issued a decision declaring that the use of lashing of prisoners within Arkansas's prisons in 1968 was a violation of the Cruel and Unusual Punishments Clause. And actually in the American penal system, we've already abandoned the use of non-lethal corporal punishments, and yet the death penalty remains. So I often like to say that the Eighth Amendment jurisprudence we have at the Supreme Court level is now kind of a Dr. Jekyll and Mr. Hyde approach, because ordinarily the Eighth Amendment is used to protect prisoners from harms, both physical harms and from sort of maybe threats of death by a prison guard, those types of things, and yet the death penalty continues.
Okay, well, thank you. And so we're going to come back to the constitutionality of the death penalty. And Carol, I want to sort of take the liberty now of trying to channel the late Justice Scalia a little bit, because I think it's important to recognize not just the loss of his voice on the Supreme Court, but this was an area that he spoke to. This is an area that he obviously wrote opinions on. And I want to just quote a little bit from John's book. In referencing Justice Scalia's views on Justice Breyer's arguments about the constitutionality of the death penalty, and recall first for Justice Scalia, of course, what would matter would be first the text of the Constitution. The text of the Constitution doesn't abolish the death penalty. It seems to contemplate that it may be used. That's what the Fifth Amendment seems to do, though it seems to put some procedural restrictions on its imposition. At the same time, then, we get the Eighth Amendment, which has this phrase, cruel and unusual, which we're about to interpret. Here's what Justice Scalia wrote in this more recent case about that in responding to Justice Breyer. Historically, the Eighth Amendment was understood to bar only those punishments that added terror, pain, or disgrace to an otherwise permissible capital sentence. And then you write, rebuking Justice Breyer's, Justice Scalia asserted, rather than bother with the troubling detail, this is Justice Scalia speaking now, Justice Breyer elects to contort the constitutional text, redefining cruel to mean unreliable, arbitrary, or causing excessive delays, and unusual to include a decline in use. He proceeds to offer up a white paper devoid of any meaningful legal argument. Now, in your book, of course, Carol, you and Jordan do talk about the constitutional arguments against the death penalty. What would be your response to Justice Scalia, and share with us some of the arguments from your book?
Sure. Well, Justice Scalia is absolutely right that the death penalty is mentioned in the Constitution. In fact, it's mentioned 3 times, or 4 times if you count the 2 due process clauses in the Constitution. So the due process clause says you cannot be deprived of life, liberty, or property without due process of law, which seems to imply that you can be deprived of life, liberty, or property with due process of law. Also, in the Fifth Amendment is the grand jury clause, which says with regard to capital or otherwise infamous crimes, you're required to be charged by a grand jury rather than just by a prosecutor. And finally, the double jeopardy clause, which is also in the Fifth Amendment, says that one cannot be held twice in jeopardy of life or limb. So Scalia is certainly correct that the death penalty is mentioned in the Constitution. But the fact that it's mentioned in the Constitution and was certainly a punishment that every one of the original colonies used doesn't really, we think, or any living constitutionalist think, bears on the question of what cruel and unusual punishment means today. Partly, I think one embarrassment for Justice Scalia's theory is that the Constitution also clearly contemplates physically torturous punishments. So the very same clause, the double jeopardy clause, that Justice Scalia points to as contemplating capital punishment also contemplates mutilation. It says one cannot be held twice in jeopardy of life or limb. Would that mean that, I mean, the Supreme Court has already held you can't be lashed, much less have your limbs cut off as a punishment for a crime. And I doubt there would be many, if any, courts today in the United States that would uphold a punishment of mutilation as not violative of the Constitution. So clearly our ideas of what is cruel and unusual change over time. And in fact, one could say that the drafters of the Constitution, in writing into the Constitution what have been called the majestic generalities of the Constitution, equal protection of the laws, due process of law, unreasonable searches and seizures, cruel and unusual punishments, these clauses are hardly self-defining, and they require the courts in different generations to bring to bear these majestic generalities to the facts of our, social and political life today, which is something that most of the court, really Justice Scalia, the late Justice Scalia, and Justice Thomas aside, the rest of the justices on the court, including, for example, Samuel Alito, who's one of the most conservative justices on the court, hardly an originalist, agrees that, for example, we need to think about the facts of today's world in construing some of these clauses of the Constitution. So one of the justices who has done that the most, who has been very active in developing a new way to think about what does cruel and unusual mean for the majority of the court, aside from Justice Breyer in dissent, is Justice Anthony Kennedy, really very much at the center of the court. And he has developed a theory that has been applied in a long series of cases by the court about how we can tell whether any particular application of capital punishment is cruel and unusual. And he says, first, we have to look to what legislatures are doing. And so he looks to see what legislatures are doing, and if there's a trend against a practice, like, for example, executing juvenile offenders, that will count against its constitutionality. And he'll ask not just whether legislatures permit it, but whether juries actually vote to execute, for example, let's use the example of juvenile offenders. So there's a kind of objective evidence that he looks at. And then he says, in addition to looking at the objective evidence of the acceptability of a punishment in today's society, the court must bring its own judgment to bear. And in the court bringing its own judgment to bear, Kennedy and the court do not mean they should just vote what they think. He said they should look at the purposes of punishment, whether or not it could be considered a credible deterrent, or whether it really is getting the worst of the worst and administering proportional retributive punishment. And so in the case, for example, of juvenile offenders, the court says, juveniles, as any parent knows, is what the court says, are very impulsive and not likely to be deterred by a threat of a punishment long down the road. And more to the point, they're less culpable for their offenses than fully mature adults would be. And for that reason, the court's judgment should judge that punishment cruel and unusual. And that's what the court has done. And that's why Jordan and I predict in our book that sooner or later, the Supreme Court will use this methodology to constitutionally abolish the death penalty per se, rather than piecemeal.
Well, thank you. And of course, we're in the season of not making predictions. Sooner or later is probably a safe bet in certain respects. But we also cannot ignore the context in which our discussion arises. So Jordan, like all the rest of us, we're aware that, that with the death of Justice Scalia, we have an open or vacant seat on the United States Supreme Court. For much of the last year, the Senate had the opportunity but did not hold hearings on President Obama's nomination of Merrick Garland to fill the late Justice Scalia's seat. Merrick Garland is the judge on the United States Court of Appeals for the District of Columbia, and thus the opportunity to make the next appointment will go to the president-elect once he takes office. So I'm not asking you to make a prediction, but perhaps with respect to the confirmation process or how you see things to some extent working out, what kinds of things should we pay attention to? What issues should we think about as we contemplate the future path for the arguments against the death penalty?
Well, certainly the election will affect the timing of the eventual constitutional abolition of the death penalty. I mean, one of the issues for folks who are opposed to the death penalty is whether they want to get the issue before the Supreme Court earlier rather than later. One of the things that's going on with the American death penalty is that it's withering on its own. Texas, where I'm from, which is thought of as sort of the center of the American death penalty, we had only 2 new death sentences in 2015, and we'll have, I think, 3 or 4 new death sentences this year. This is in comparison to 40-plus death sentences a year in the 1990s. So the American death penalty is winding down. The number of death sentences nationwide is down 85% from just 25 years ago. So one of the questions is whether or not the death penalty should just be sort of left to die on its own without the additional push. The only way for national abolition to occur would be through a constitutional decision. There are just too many states that will hold on to the death penalty until it's constitutionally prohibited. But a number of states have been repealing their death penalty statutes. 7 jurisdictions repealed death penalty statutes in just the last 10 years. One of them, a red state, was Nebraska, where the legislature overrode the governor's veto to abolish the death penalty, only to have it reinstated by a referendum, an initiative in Nebraska this year. So it may not be an issue that gets to the Supreme Court in the next year or 2 or 5 years, but I think if the trend continues in which death sentences are such a marginal part of our criminal justice system, in a country that has 15,000 homicides, if we have, like we had this year, fewer than 40 new death sentences to respond to 15,000 homicides, the death penalty is no longer doing any work from a penological perspective. And if you follow Justice Kennedy's logic that the death penalty has to either serve as a deterrent or serve retributive purposes to be constitutional, that it would be cruel to execute people where there were no meaningful social gains at the end of the tunnel, then I think that the withering of the death penalty sort of projects the future constitutional invalidation of the death penalty, but maybe not in 5 years, maybe in 10 or 20 years.
Well, no, this isn't being recorded, so you won't. I'm just kidding. It's of course a critical thing to keep in mind, whether politically it loses support and withers away, as you say, as some laws have done, like the Alien Sedition Act, Independent Counsel Act, are just 2 examples of that, or whether it takes a decision of the Supreme Court in a sense to bring it down. We don't know. But having introduced both Justice Scalia and Justice Breyer into the same conversation, introduces a separate issue which is addressed in one of the questions from the audience, and that is the debate between Justice Scalia and Justice Breyer over the relevance of relying on international law in making a constitutional decision. John, you had made reference to it in your remarks, and obviously it's part of the opinions you have here. The question from the audience is, should the abolition of the death penalty in other countries matter to how we understand its unusual status here? I might add to that sort of, why should it matter?
Sure.
How and why?
Well, first a couple of points there. Justice Scalia, late Justice Scalia, was interesting in the sense that he once gave a speech saying he referred to himself as a faint-hearted originalist because he had to deal with this problem of the fact that at the founding era, we still used the pillory, we still used ear cropping, we did use mutilating punishments at that time, and Justice Scalia said, well, he couldn't conceive of a judge who would go back to that. Now, he did later retract that statement. He said it would be...
Bring on the pillory.
He said it would be stupid but constitutional. But I think that is an issue for most judges, that they can't conceive of themselves imposing those types of non-lethal corporal punishments any longer. The other thing that's also, I think, interesting before I get to the question is this issue of the change that we saw in the Constitution with the passage of the 14th Amendment. In response to some of the things that Carol was talking about, we had the Congress pass the Civil Rights Act of 1866, which required like punishments for whites and blacks. And because the South was not following that, the Reconstruction Congress decided to put in place the 14th Amendment, which requires equal protection of the laws. And we just haven't seen that. Despite all the efforts to regulate the Supreme Court that Carol and Jordan's book so deftly goes into, we still see those who kill whites are much more likely to be punished by death than those who kill blacks. And so we do not have equal justice under law. And I think the 14th Amendment really fundamentally changes the 8th Amendment sort of calculus about what is a cruel and unusual punishment, because if it's not equal, it can no longer be cruel. And actually, part of the impetus for the 14th Amendment was that we wanted to have equal punishments, and we still don't see that. The founders themselves looked to a lot of international law issues. They read international law sort of jurists. They were very interested in this idea of natural law. They looked to the French Enlightenment, to the Italian Enlightenment in particular, where they were reading all these authors. And so I think the idea that we're completely in isolation, we should look nowhere outside the United States for any kind of information is really just ridiculous. And actually, Justice Breyer, in his book, Called to Court in the World, makes the point that even if you don't like international law, even if you don't like foreign law, the Supreme Court itself cannot avoid addressing issues of international law because we now have things like international adoptions. The court has to address international issues. And one of the things that I'm working on now is a book called The Death Penalty is Torture. And traditionally, the death penalty and torture have been seen in separate legal silos. But in Europe, it's no longer legal to use the death penalty. And the Supreme Court has sort of focused very narrowly on whether there's a risk of physical excruciating pain at the moment of death with the use of lethal injection drugs. And the court has not really looked at the psychological aspect of the imposition of a death sentence itself. And this is actually one of the things, right before Furman was decided, there was a case in California, People versus Anderson, where the California Supreme Court, in striking down the state's death penalty at that time, referred to the mental torture that was associated with the death penalty. And the Torture Convention, which we've signed on to, prohibits both physical and mental or psychological pain or suffering that's severe for purposes of punishment. And so I think international law, the Supreme Court has never really gone full in on international law. In fact, even when Justice Kennedy referred to international law in striking down the juvenile death penalty, he said, well, if we look at international law practice, it's confirmatory, but we're not relying exclusively on it. But I don't think that the judges are in a bubble. They're going to conferences in Europe often. They're interacting with other judges from other legal systems, and I don't think they can totally ignore what's happening in other parts of the world when they think about this issue.
Okay, thank you. So, Carol, we're back to the language. We're focusing on the language, cruel and unusual, and we have a couple questions from the audience that are zeroing in or focusing on the long period of incarceration prior to the imposition of the death penalty. So, as one question puts it, isn't the long period of incarceration before execution in and of itself cruel and unusual punishment?
Yes, this is one of the arguments that Justice Breyer makes in his glossip dissent about the lackey kind of claim about you're punished twice. You're punished by, on average, 18 years on death row, waiting for your execution, and conditions on death row are really, in some ways, a form of torture too. You're mostly, if you're on death row, most states have pretty much solitary confinement for people on death row, alone in their cells, 23 hours a day, allowed out to exercise for an hour by themselves in essentially like a dog cage, no contact visitation of any kind. And imagine life like that for 18 years, followed by execution. And so I think the idea is that there's concern about whether or not these lengthy periods by themselves are a form of cruel and unusual punishment. And one of the things we say in our book, in the chapter that's the last chapter in our book, that's my favorite title of a chapter, where we talk about imagining a day when the death penalty is abolished constitutionally across the country, what will happen then? The title of the chapter is Life After Death. And we think that at that moment we'll be able to have a more honest conversation about the punishment of life without possibility of parole, which has originally been kind of embraced by death penalty abolitionists as a way of making people more comfortable with getting rid of the death penalty. Don't worry, these people will never get out. But unfortunately, that punishment has been so widely embraced that it's now used for many, many people who would never be eligible for the death penalty. So we are the country in the world that also most widely uses this punishment. And in the absence of the death penalty and after the death penalty, and maybe even before the death penalty or at the same time that we consider the death penalty, we could talk about whether these lengthy lifetime periods of incarceration themselves are cruel and unusual punishment. Death is not always the only thing that could be akin to torture.
Well, I sometimes remember being in a moot court argument with Pam Carlin, which she said, isn't the imposition of a life sentence a sentence to death? Jordan, we're running out of time, so I'm going to ask you a two-part question. You give you a little more time here, and then I'm going to come back to Carol and John for any final thoughts. Two-part question is first going to pick up a little bit on what we were talking about just now with costliness. So the question from the audience is, how does one justify the continuing cost of life imprisonment as opposed to the death penalty? And then the second is, I know there's another case in Vermont that's working its way through the system, and maybe we could talk about that in your closing thoughts as well.
Yeah, I'll talk about cost first. For many, many years, the issue of cost was always thought to be a pro-death penalty argument. The cost of keeping someone alive in prison was far in excess of what it costs to execute someone. And that was true for most of our constitutional history, for most of our history. But once the death penalty became regulated by the Constitution and capital trials became to look so much different from non-capital trials, and the cost of appeals and post-conviction became so much more expensive, we're now at a point where the death penalty is vastly more expensive than sentencing someone to life imprisonment. And this is what mostly accounts for the enormous decline of the death penalty throughout the states. It's not that in Texas there has been a sudden change of heart and that prosecutors no longer believe that the death penalty is a good and appropriate punishment. It's that prosecutors are facing tens of thousands and in many cases millions of dollars to litigate capital cases where the cost of life imprisonment is much smaller than the costs associated with capital prosecution. So I think cost, rather than on many of these concerns about human dignity and double punishment and the cruelty of death row, I think it's cost. It's the sort of prosaic concern of cost that's actually going to end the death penalty in the United States, whereas in Europe and most parts of the world, it's loftier concerns about human dignity. In terms of the decision, the most recent decision, it's a very interesting decision that was issued yesterday by a federal judge in Vermont. Vermont is a non-capital state, but the United States has a death penalty, and they chose to pursue a capital prosecution in Vermont. And the judge there, I think inspired by Justice Breyer's lengthy dissent in the Glossop case, decided to hold a week-long hearing on a motion to strike the death penalty as unconstitutional, basically wanting to build the record that Justice Breyer and Justice Ginsburg called for in Glossop. And he held that hearing, had numerous experts testify, including my sister, and he wrote a lengthy opinion in which he basically reaches the conclusion that Justice Ginsburg and Justice Breyer suggest, that the death penalty is likely unconstitutional under the Eighth Amendment for a variety of reasons, including arbitrariness, cost, and error. But he also believed that it would be inappropriate for a federal district judge to issue that ruling in advance of a direction from the US Supreme Court. So this is a case that's building the record for a case that might ultimately arrive at the court where the Supreme Court can decide again. It's only faced this question once in its history in 1976, whether the death penalty as a punishment is unconstitutional, and this federal judge at least believes that it is.
Thank you. We are obviously running up against the end of our time, but Carol and John, each of you for about 30 seconds. Any final concluding thoughts? Carol first.
Well, I think this recent decision is, as Jordan says, a kind of vindication of our own prediction about the eventual future of the death penalty, whether it's in the short term or really depending on who's on the Supreme Court, the longer term, a generation or so. We feel pretty confident that the death penalty is on its way out as an American institution, but that the only way that places like Texas or Alabama or Louisiana will fully abandon the death penalty is if the Supreme Court tells them that they have to. But we think that day is coming. And I'm sure John may say, hopefully when Justice Breyer is still around to enjoy it.
John, final thoughts.
Yeah, I mean, I think that right now, we think back to the history where we began. Beccaria, he wrote about torture and capital punishment in separate chapters of his book on crimes and punishments. And I think we can conceive of a future where we might think of torture up here and lethal forms and non-lethal forms here. Actually, right now, mock executions or simulated execution are considered a classic form of psychological torture. The Supreme Court, again, has not focused on that yet, but I think in the future that may be the direction that we're heading in terms of the law.
Thank you. We've had three terrific legal scholars, three terrific authors who are going to be downstairs signing their books in just seconds. But let me again thank John Bessler and the terrific brother-sister duo, Jordan and Carol Steicher, for joining us today in this excellent discussion, thank you.